alternative dispute resolution is in no way a silver bullet for every project. There are certain cases where it will work, and there are certain cases where it will not work. But our model is to figure out where those cases will be successful and push those as far as we can to get more immediate successful results than we could through other channels. The other thing we do is hold the investors accountable for financing projects that violate human rights and environmental rules. So for example, the World Bank and OPIC, the two institutions I've given as examples so far, and we work on about a dozen of such institutions, they all have social and environmental and human rights rules that they're supposed to follow before deciding to invest. And when they invest, regardless of those rules and in spite of those rules, the complaints we file can say, not only do we want dispute resolution, we want a second thing, and that second thing is we want an audit. We want an audit of whether those rules were violated in the financing of this project. And in this Mexico case, we asked for an audit. There was an investigation that found that there were violations. OPIC management, the staff that designed the project with the company, allowed the project to go forward, agreed on those recommendations, and those would be implemented to avoid future harm, hopefully. So, our model, first of all, is to support communities, and I discussed that already, a little bit about how we do that. Communities come to us with requests through a network that I'll discuss later, and we help them figure out whether they can submit a complaint to a non-judicial grievance mechanism, and those are the complaint offices I described, and then we help them in follow-up in order to actually file a complaint, in order to help them negotiate with a company with vastly unequal bargaining power to what they may have locally to help even that playing field a bit. And then the second thing we do is policy advocacy, because the accountability mechanisms we use, these complaint offices, are only as strong as civil society requires them to be. So these mechanisms are only about a decade old, most of them. They're in the scope of international law and the history of the world's legal systems and dispute resolution systems. They're babies, they're infants. So they're still developing. So it's a really exciting field to be in as we're watching these mechanisms evolve. But that also means the rules are still up for debate. So, how you file a complaint, whether it's transparent, whether the eligibility criteria are fair when you're filing a complaint, all of these technical details matter a lot to the outcome and whether our client communities are able to receive a fair shake and a just result. So our policy advocacy focuses on that. Are the institutions set up to receive complaints, these mechanisms, independent, fair, transparent, and accessible tools for justice? And if not, what can we do to ensure that they are? So as I mentioned, we do community trainings. This is a picture of one of our trainings in Peru. And we work very closely with local NGOs at every step of the way, from the initial conversations with communities. This is one of the indigenous federation leaders in Peru, all the way up to international and national NGOs to work in coalition so that we're getting as much support as we can from existing resources. And now, just to give you a brief synopsis of where we are located, which is everywhere. So, we have, I think the current count is that we have 9 active cases around the world. I have staff that are in Mongolia today, in India today, that just returned from Liberia. Then we have the rest of the cases we're working on with local partners that are doing the intensive fact gathering and interviewing, and they work with us to have us help with the technical drafting of complaints. So we really work in partnership as much as we can. And I would add that we're a small organization. We're 3 full-time staff. We work with law students, the law clinics of law schools, particularly in Berkeley. We're based in San Francisco. And we have pro bono lawyers working for us as well. So that's how we're able to multiply our impact. But our 3 staff do the bulk of all of those cases you see there. So now, the point of the talk. My long and winding road. So how did I get to be doing that very somewhat esoteric niche kind of work, which is focused on accountability of internationally financed development projects, which to me was just a way to get at the goal that I started at right even before the Cornell emblem over there, which was when I was a kid, really before I even went to high school. I knew I wanted to work on justice issues. I knew I wanted to work on environmental issues. Those were issues I was very passionate about from a young age. And the question was how? How am I going to work on those issues? How am I going to be most effective? And how will I take advantage of the education that I'm being given and that I'm working hard to get for myself, but that I'm very privileged to be able to acquire? So I'll give you a little synopsis, and then I want to make sure I leave plenty of time for questions, so I'll just give you a quick synopsis. So going back to that thinking, Cornell really was a pivotal time for me in my career. As was mentioned, I was a participant in the Cornell in Washington program, and that was a semester that changed my life. I did an internship during Cornell in Washington at the Center for International Environmental Law, where there were 2 lawyers working part-time on helping communities bring complaints to the accountability mechanisms. In particular, the World Bank's inspection panel, which at the time was the only accountability office in the world. It was the very first one. So when I was there in 1998, that was the only game in town, was this one mechanism. And I thought, oh my gosh, these communities have such leverage. And watching these lawyers work with these, in that case, Paraguayan villagers, who were able to come and visit the World Bank's board of directors and speak to the board members. Where else do you see that kind of direct power rebalancing? That direct kind of relation of the people being harmed with the decision makers causing the decision making that creates that harm. And it seemed to me a vastly underutilized tool, and remained so when I founded the organization in 2009. So that line connects pretty directly in terms of the issue and the tools. But as you can see, we took some detours to get there. So I had another couple. I was a Cornell Tradition Scholar, and thanks to Cornell Tradition, I was able to spend a summer working in Chile at an environmental NGO where I witnessed the World Bank's private sector arm building a dam on the Bio River. And that was a case that was not eligible to go to the inspection panel, that very first accountability mechanism, because the panel only had jurisdiction over public sector finance. So if the money went to the government, you could complain. If the money went to a corporation from the World Bank, you were out of luck. And you couldn't sue them because they were immune from suit. There was just nothing you could do. So how was that redressed? A new accountability mechanism was created because civil society demanded it. A small group of NGOs, non-governmental organizations around the world, demanded that the World Bank create another accountability mechanism. And I work bringing complaints to that mechanism today, all the time. So that's another one of those direct lines from Cornell to the present. When I was in Chile, I witnessed the Chilean police tear gassing 80-year-old Mapuche women who were standing on the banks of the river saying they did not want the dam to come and destroy their lives and livelihood, and the police stood there saying, get out of the way. And there was nothing they could do about it, and as a U.S. citizen, my taxpayer dollars going to the World Bank were financing this project, and I felt a responsibility to help recognize what tools exist, and if there were no tools, to help create the ones that we could create to help redress that problem, that great injustice. So I described my pivotal time at the Center for International Environmental Law in Cornell, Washington. I graduated, I went to UCLA Law School. I acquired even more debt, and was a student of the Public Interest Law program. And during my time at UCLA Law School, I spent my first summer at the World Bank working for the inspection panel that receives these citizen complaints. And this is one of my first lessons of my lecture, I didn't know exactly where I was going to end up. As you know, I wanted to work on human rights, environmental issues, justice issues, but I didn't know how or where. Once I started being very curious about these non-judicial recourse mechanisms, I did intentionally set out to learn as much as I humanly could about them. So in college, my Cornell, Washington thesis was about the Congressional Replenishment Program. That was how NGOs demanded that accountability mechanism be created. So that was the first thing I did. So from a congressional perspective, I understood the mechanism of how citizens use Congress to leverage power to change. At CL, I took it at another angle. How do communities use the mechanism themselves to use the complaint process to get justice? And then here I am at the inspection panel saying, okay, from an institutional perspective, what's it like to receive one of these complaints? What can be done about it when you receive one at the inspection panel? What are the limits to those powers? How can those powers be exploited at the inspection panel? What are the politics that are the barriers for the panel's work and challenges for the panel's work? And how is the panel perceived within the World Bank? So all of those questions I was able to really explore by working there as a consultant on a particular case in Ecuador in the year 2000. So I was spit out of UCLA, I graduated, and meanwhile I did another set of explorations which led to that big curve you see up there, which was litigation. So now here I am a lawyer, I have the ability to go into court and sue somebody. If I want to sue someone for corporate atrocities, for corporate human rights and environmental abuses, is that an effective tool? I was asking myself, is it better than using these non-judicial accountability mechanisms? So I wanted to find find out. So while I was still in law school, I wrote a law review article on this particular law called the Alien Tort Statute, a very esoteric law that's become less esoteric during my career. But I reviewed all 200 cases that had ever been published, opinions at that time, to really understand whether this was a viable tool for my would-be clients in my future.